Should firearm bump stocks be banned in the United States? This is part 2 of the consequential cases the Supreme Court heard just this week. Part 1 was about the social media case that could impact all of our free speech rights online, and this part is focusing on the gun rights case that's trying to overturn former President Trump's ban on firearm bump stocks. Believe it or not, this case has nothing to do with the Second Amendment. But before I explain what's going on, you have to understand the backstory. First, what is a bump stock? It is an attachment that enables a semi-automatic rifle to fire faster. Back in 2017, a 64-year-old man was able to kill 60 people and injure more than 850 others in a horrific mass shooting at a Las Vegas music festival. He used almost 24 weapons that day. The majority of them had bump stocks attached. Within a week of that massacre, the National Rifle Association announced it would support tighter restrictions on these bump stocks, and former President Trump started the process to ban them. By 2018, then President Trump was successful in his bump stock ban, and bump stock owners were given until 2019 to either surrender them or destroy them. Trump was able to ban bump stocks by adding a definition change to the 1986 Firearm Owners Protection Act. That law prohibits the possession of a machine gun that was not legally owned before 1986. That law defines machine guns as firearms that shoot, are designed to shoot, or can be readily restored to shoot automatically more than one shot without manually reloading by a single function of the trigger, as well as any part designed and intended solely for use in converting a weapon into a machine gun. Now, I know that's technical, but it's important because Trump then ordered the ATF to come up with a rule attached to that law banning all devices that turned legal weapons into machine guns. So the ATF reclassified the definition of bump stocks using that 1986 law, saying under federal law, bump stocks allow a shooter of a semi-automatic firearm to initiate a continuous firing cycle with a single pull of the trigger. Therefore, they qualify as a machine gun and therefore are illegal. So that's the backstory. Well, after all that happened, a gun shop owner in Texas sued the federal government over Trump's bump stock ban, saying the ATF overstepped its authority when it reclassified bump stocks into the machine gun bucket. The lower courts sided with the ATF and said the bump stock ban was totally legal. But the Fifth Circuit Court of Appeals sided with the gun shop owner and said weapons fitted with bump stocks cannot be classified as machine guns. And that's how we got to the Supreme Court this week. Obviously, the Biden administration argued the Trump administration was right to ban bump stocks, and they want the Supreme Court justices to keep the ATF's definition in place. During oral arguments, both sides were not arguing the Second Amendment. Instead, they were arguing the administrative rule change by the ATF under Trump. So they were really arguing about how bump stocks technically operate and whether they can be put in the machine gun bucket because of that. The justices seemed really divided. Some questioned whether that 1986 law covers bump stocks at all, and others suggested a rule change isn't enough, that it should actually be Congress that bans bump stocks, not the ATF. Now, there's no way to know which way the Supreme Court is going to rule on this one, but we are expecting them to decide by the end of the term in June.